everybody to take their seats. We're getting ready to start.
Okay. We'll be getting ready to start our next session now, so if you would kindly take your seats. It's wonderful to see everybody here in person. It's really nice that you all came. For this panel, it is our State AG panel, and I'm going to introduce Leah Nyland. She's the antitrust reporter at Bloomberg News, which is different from Bloomberg Law and different from Bloomberg Government. Her stories appear on the terminal. So just want to hand it over to Leah.
Thank you so much, Sarah. We're going to get underway in just a second after I introduce everybody. You can ask questions on Slido, and I will get them right here so we can ask them during the conversation. I'm also going to leave about 10 to 15 minutes for audience questions at the end, so please be thinking of those. So today we have Doug Peterson, who is the Attorney General of Nebraska, longtime Attorney General. How long have you been?
It'll be 8 years.
8 years, yeah. And we also have Phil Weiser, who is the Attorney General of Colorado. So sort of the first question I wanted to put to you guys is what do you see as the role of state attorneys general in sort of the tech debate, whether that be privacy, antitrust, and the digital economy?
Well, the Attorney Generals have had a long history in antitrust. It goes back to actually goes into the late 1800s. So we've been engaged in antitrust, and then with the consumer protection laws and privacy issues there, they all fall within our jurisdiction. What I would say is a little bit different is with technology, attorneys general have become aware of the importance of data. We've had several opportunities in the last 4 to 5 years of seeing how concerning that is. And so I think the model that you're seeing now among AG engagement in antitrust is probably a different model that has not actually been played out before. In the consumer protection area, there has always been a long history of large multi-state efforts to protect consumers. And certainly now there's been an awareness, for example, social media platforms and the impact on young people and other areas where technology has created concerns for our consumer protection laws. Those are probably operating in a little bit more traditional manner. I think the antitrust one is that the tech issues have kind of awakened a lot of states that weren't very engaged in antitrust. And what that has done is created a force multiplier for the states to be active enforcers in the area.
Phil?
40 years ago, we would not be having this conversation. When you think about the AT&T case, state AGs were not a player at that point. So 2 things have happened in the last 40 years. States have become more significant as actors in the tech and digital space, and the federal government has become less able to act. 40 years ago, Tim Wirth and Tom Talkey were the respective leaders of the House Telecom Committee. They were holding hearings about the AT&T case, as well as about other emerging issues like the '84 Cable Act. And we had at that point a high-functioning Congress who could pass legislation. I was not meant to be a laugh line, but alas, unfortunately, here we are. So what's happened in this state and state AG world is actually a critical part of this, starting with the tobacco litigation in the mid to late 1990s, the Microsoft litigation where you had state AGs actively involved. State AGs started to build this capacity to work on a multi-state basis in a problem-solving mode that has continued to be high-functioning. And the cases that Doug has provided incredible leadership on are in that mode. As per the left line, the feds are not necessarily leading on these issues. I worked for President Obama a decade ago. We had worked on a privacy bill of rights. That concept still is on the drawing board, and kind of like rooting for the Mets or the Rockies, my 2 favorite baseball teams, it's always wait till next year. And we'll see if we get a federal privacy law. It would be the first best world if we could have one, but in the reality, the states are where the action is, and Colorado has passed the Colorado Privacy Act.
The one thing that has always interested me about the state attorneys general is their ability to work a little bit more on a bipartisan basis. I wonder if you guys could talk a little bit actually about how that has worked out and why you think that is.
You know, one, I think most AGs look at their role as being problem solvers. And so when you identify some pretty clear bipartisan issues, it's easy to get on the phone and to recruit. As I think is well aware of our social media platform investigation, it was I would say very easy to pull AGs into that because so many attorney generals could identify family members or others who've been impacted, their children, their grandchildren, children that they know have been impacted adversely by the amount of time they spend on social media platforms. So I use that as an example to say, within our jurisdiction and the issues we address, if you focus on what is the problem, the harm, and it doesn't really have a blue or red color to it, it's simply a harm, it's much easier for us. And I think that's what's been somewhat unique, is that we can engage and be productive and not have to, frankly, the politics are kind of on the fringe and we stay focused on the harm.
I would add to that the fact that we are all lawyers and have a rigor that our profession develops matters, and the fact that we all operate in a world where we have to demonstrate facts with legal standards to courts has another discipline to our work. The challenge for Congress is to provide rigor and discipline in problem solving, and that challenge is an acute one for our nation's governance. The model that state AGs operate is highly functional, and it's not only on the issues that we're talking about today. I would highlight opioids as another example where you had all the states work together with nationwide implications and resolution of a real crisis. It's for the same reason that Doug mentioned around social media. All state AGs, from red, blue, and other categories, see the challenge of our opioid crisis and also saw, based on the facts, you've read Empire of Pain or watched Dopesick, there were actors who acted in a way that warranted accountability. That type of watchdog role is one state AGs have historically played, and it's a critical one that we can keep playing on a bipartisan basis.
Since you guys, I was going to leave it till a little bit later, but since both of you mentioned it, can you talk a little bit about the social media investigation? I know it's ongoing, so there's limited amounts of things you can say, but what can you tell us about it?
It's ongoing. Oh. It's interesting because, and we'll probably talk about this more later, but I mean, there are constant articles. Wall Street Journal's done a lot of work doing investigations on this. There's constant information coming out. So we have efforts in DC, we have state laws being passed on privacy. I mean, there's a lot of balls in the air, a lot of engagement going on in the topic. And so this is just one part or element of it. One of the things that's always frustrating is, as opposed to being in private practice, and even litigation in private practice, you could kind of control the time period. It's just frustrating in watching this whole arena of an industry that moves very quickly and a system that moves very slowly, but we're moving.
Let me address it this way. Every single platform or fundamental technology that our society has had has experienced a form of regulatory oversight to address public concerns. With social media, teen mental health is what we're talking about in this matter, but you can add to that list robocalls. No. You can add to that list. There's public safety, real concerns about stolen goods being sold on Facebook Marketplace. Colorado passed a law recently requiring identifying information about people selling on marketplaces like Facebook Marketplace or Amazon's Marketplace. Democracy, political ads not being required to be disclosed on social media platforms. We've talked about privacy, we've talked about competition, algorithms and discrimination. So right now, part of the challenge that we're having is, to Doug's point, the law catching up with technology is a major issue in this moment. And the less Congress is able to act, the more that puts the burden on the states to act.
Speaking of a case that's going to take forever, the Google case, one of the ones that you guys brought back in 2020, it's now expected to go to trial in 2023. I wondered if you could talk a little bit about both that case and sort of in cases that are going to take a very long time like that, how do you try and future-proof them? And also, I mean, how do you think about the fact that this is going to take a really long time, even at the beginning of an investigation?
Well, it's a good question. Does it demand an answer? I think we've recognized, and there's been plenty of publications on this, that when you come into an antitrust case and you say, okay, where are the anti-competitive behaviors, and if you were successful to show a Section 2 violation, what would be the appropriate remedies? All of that within not just this lawsuit, but any antitrust lawsuit that states look at is always a challenge, because when you're thinking about the remedy, the whole framework of the business model may change 4 years, 5 years down the road. So this is, I think, from time of investigation to time of trial will certainly be over 4 years. If I talk long enough, I'll forget your question. But, you know, I do think what has changed a little bit is, and this might be outside the scope of your question, but I see some of the questions flying down here. I think there used to be, the Microsoft case was a good example where there were 20 states that joined in the Microsoft case. They got through the liability issue, and then basically the Department of Justice reached a resolution with Microsoft. Now that resolution has had impact. It's actually opened up markets. In this particular case, what's a little bit different is that the fact, and frankly in the Microsoft case, I think New York did decide to go forward on a little bit different damage resolution. In this case, we have really, on the state side, built it out with retaining our own experts and other important litigation strategies where that we will maintain our independence, because I think both Phil and I had a concern that historically states became too dependent upon the Department of Justice as to strategy, as to resolution, things of that nature. And we never wanted to give up our sovereign authority to do that, but rather built out our case so that we could control possible remedies.
So let me acknowledge that antitrust has this tension of often requiring some level of retrospective analysis to make predictive judgments and remedies. And in fast-moving industries, that is a real puzzle. With the Microsoft case, as Doug noted, there are a lot of critics that said that the DOJ didn't ultimately solve that puzzle, and so we are aware going in we have that challenge. I do think part of the timing of this Google search case could look like this. Google built a highly successful product and got a dominant share on the desktop. And in retrospect, there were some strategies used to help it get dominance in mobile. And as we look at those, for example, the restrictive agreements with Apple, et cetera, what is the next platform that is going to matter for search? Connected cars, just one example. Insofar as we can ensure platform competition, an open playing field, we will benefit consumers, will benefit innovators. That's what the antitrust laws need to accomplish. That's what we have to be thinking about. And as you look at our complaint, you'll see it captures different types of remedies that would be envisioned to enable competition on the merits and restore competition to the search marketplace, both search and search advertising.
Great. I did want to give you guys a chance to sort of weigh in on antitrust reform, which is still pending in Congress. I know there is one bill that is specifically focused on the powers of the state AGs. So what are your sort of thoughts about those?
Well, Phil and I were talking that earlier this morning about The jurisdictional one for the states to be able to maintain filing an action in their own state and being able to keep it there and not be pulled into a multi-district federal claim. That seems to be, it has bipartisan support. There's not a lot of pushback. It's pretty simple. I think also the fees, merger fees application, these are kind of process ones that shouldn't get a lot of excitement as far as passage. Excitement for us in that we like it, but it shouldn't create any conflict. It's my understanding, it goes to Phil's earlier point, something that would be fairly simple like that should be something you would anticipate being passed and signed, and it's not. It's being held up, and so that's frustrating. And then even some of the other laws, I think, have some bipartisan support because, as I said earlier, I think whether it's at the state level or federal level, everyone is starting to recognize these real legitimate concerns of data, privacy, data control, and so I think it frankly puts on a little bit greater burden on the states to be responsive because we certainly seem to be more nimble than the DC process.
I agree. These two laws, the merger filing fees, the state venue law, and maybe even the privacy law proposed in Washington are in the categories of no-brainers. There is no such thing as no-brainer in Congress. If there was, the Safe Banking Act would have already been passed. That's a law that has great public safety benefits, and it makes a lot of sense not to have people in the cannabis business operating in cash, which is a hazard. But that law hasn't passed either. So I'm not going to hold my breath that these laws get passed, but as I look at the merits of them, I've yet to hear arguments on the merits really against them. They make sense. There are other measures in Congress that I recognize in the antitrust area may have more, let's call it, nuanced conversations, difficulty, valuable debates. I don't see these ones as ones that really should be held up because we don't know enough about whether states should be able to control their own venue. I think the point is, as a state sovereign enforcer, we should have the same basic standing as the federal government does, which is when we sue in a particular jurisdiction, we shouldn't be subject to being pulled into a multi-district litigation panel.
Thanks. I want to move on to privacy. And as you mentioned, we still have no federal privacy law, but the states have been sort of acting in the place of that. And Colorado is among those who has passed its own state privacy law. Can you talk a little bit about the new law and when it goes into force?
Let me start with the why here. When I show up across our great state and I talk to people, people say, why is it that companies are collecting data about me, selling that data for advertisements based on profiles about me? I don't know what is happening. I can't see if the data is even accurate, and it feels kind of, to use Doug's word, creepy. To which my answer is, yes, I hear you. And they said, well, why don't we do something about it? And a group of bipartisan members of our state legislature did something about it. The stakeholding process and the rigor of this process that we were heavily involved in is a model of what I believe problem solving should look like. Colorado's law is, to my mind, a thoughtful model. It includes addressing the points I mentioned. If you're collecting data that you're going to share, monetize, you need to tell people their data is being collected, and you need to give them the ability to opt out of having that happen. You have a right to look at the data and to say, wait a minute, this is wrong. And we also want people to have a universal opt-out opportunity, so we make it easier on people to opt out. We also believe that companies should have some form of a data assessment requirement where they ask the question, how am I storing data? How long am I storing it for? Do I need to store this data? Many companies are well along their way thinking about how they protect customer data. Others, this is going to be a transition. And so to your point about timing, we're currently in an informal stakeholding mode. We're going to move to a formal rulemaking mode where we'll propose rules that people can comment on with the goal of adopting them ideally later this year, early next year, before the formal law goes into effect in May 2023. We know we're going to keep adjusting our regulatory framework, and I said we need rulemaking authority in our office to make this model work, and we have it. And what I've said about our enforcement of the law is we're going to focus on those engaged in willful non-compliance, and I've said this about our data security law too. I'm not interested in penalizing people who are really trying hard to make a foot fault. But there are a lot of companies who may say, I don't care. I'm not going to follow this law. Those are the ones we're going to start by going after.
There have been some efforts in Nebraska as well to enact a privacy law. I don't think you guys made it across the finish line in the last legislative session, but I wondered if you had any thoughts on those and like what's the possibility of Nebraska passing its own?
You know, I would say historically, you know, the argument that for federalism is that the states are the great experimental labs. Well, we want to see if there's any blow-ups in any labs and to avoid their strategy. No, but I think there's just a few senators who got behind that, and it was a busy legislative session. So I don't think it died for lack of interest or concern, but I do think historically what you see in the Nebraska legislature is watching some of the models play out, and I think Colorado is one that we will watch before anyone feels comfortable enough with proposing the legislation. And then you'll get more of a consensus with that type of opportunity to review.
There's a couple questions on the Slido about this. So what do you guys think the relation between state and federal privacy laws should be? And how are states viewing federal privacy bills with broad preemption of state laws?
I'm very pragmatic on this. If a federal law is as good, as strong as what we worked on in Colorado, I am comfortable with that law preempting Colorado, provided state AGs have the authority to enforce federal law. That's the same model we have under Dodd-Frank, for example. It's important to me to have that model because you could imagine a world where the feds are not engaged in active enforcement, then the states can pick up that slack. I don't need to have the ability to have standards different than the federal standard. I think there's obviously a great virtue to a single standard. If you do have multiple standards, we have to solve for the problem, which is a problem right now, of what I'll call interoperability or harmonization. How do we make sure that different state laws enable compliance across them, as opposed to put businesses in, to me, the unacceptable position of saying, I can either comply with Colorado's law or California's law, but not both.
Do you have any thoughts?
I think Phil had commented earlier that in the perfect world, having a really strong federal law would make the most sense for compliance for so many different companies. I don't think that's going to happen. And I do like the question is, in these different states, how have they identified the problem and who are they going to sources for answers? And if it gets politicized, you know, then you're not going to get the best product. So I do, from having a federalist type perspective, I frankly am comfortable, but I've seen the states build out models to address the concerns that the policymakers have identified. But I think ultimately what will happen is there's going to be some federal law passed that will preempt. I'd heard one person comment that they felt that the California laws, the two California laws have been passed, in some ways because of industry saying, well, if there's any market that's large, we're going to follow that. And so that market size almost has a preemptive effect on other states. But I think from Nebraska's standpoint, we will come to the show after we've seen enough activity.
So last night we heard a lot from NTIA Director Alan Davidson about efforts to expand broadband in the state. So I did want to give you guys an opportunity to talk a little bit about how your states are working with the federal government or otherwise to expand access to broadband.
Well, it was during the pandemic that Doug and I were talking about this issue, and we worked on a letter calling on Congress to fund broadband so that we don't have a continuing divide with some haves and some have-nots. And Doug, I don't remember how many state AGs we got on board, but it was a overwhelming number. It met what was called the National Association AG policy, NAG policy. So the National Association AGs was lobbying for broadband in what became the Bipartisan Infrastructure Act. As we represent our citizens, we saw during the pandemic, people couldn't learn if they didn't have broadband. They couldn't get health care. They couldn't have economic opportunity. This is a critical challenge, And state AGs are going to be involved in it. For the first step, of course, is whether or not the map is reliable. I've actually hired in Colorado, probably not many states can say this, an assistant attorney general for broadband to make sure that we do a good job developing this map. And then we have the next challenge of the plan and having an ability to execute on this plan to get the money well spent. The earlier era that a number of us were a part of during the stimulus under President Obama, we had the unfortunate situation of giving out the money first, making plans second, doing maps third. I'm really glad we're reversing the order, doing the maps first, doing the plans second, then giving out the money. It's so important. We got to get this right.
Yeah, I was looking as we first sat down here, and I was seeing the slideshow that on the broadband, and there's a big white space, which would be Nebraska. Now, you have to understand we have more cattle than people in Nebraska, and in a lot of that area, it's primarily occupied by cattle. But we did, that was certainly a concern because broadband plays such an important role for education, such an important role for business. So when the Sprint T-Mobile merger was being discussed and the Department of Justice was working out an agreement, we decided not to be a part of the lawsuit because we felt that there were some assurances in there that would make sure that that map changed. And to T-Mobile's credit, we've stayed engaged in conversations to see that that can happen. So it's really upon DOJ to make sure the terms are enforced, but I think it's been helpful as AG to stay engaged in the progress reports that we get from T-Mobile on what that looks like. But it's important because it affects a lot of these rural areas in Nebraska that have been underserved.
The sort of last topic I wanted us to talk about is one of the ones where the states have been active, and I think there is a little bit less bipartisanship than on some of the other issues like antitrust and privacy, and that's sort of Section 230 and content moderation issues. Doug, I know that you had actually been pretty active in the Section 230 reform, and you had spoken at the Justice Department's workshop under the Trump administration. So I wondered if you could talk a little bit about what you think needs to change there, and we'll go from there.
Well, I think there are some common agreements that people can have that when that Section 230 was created in the late 90s, it was a whole different world as to what the tech industry looks like today and the content on social media. And there's still this tension that they understood why that was necessary, but the market has changed so much. I think it's foolhardy for me to sit up here and try to say, well, here's where I see the answers to Section 230. I can see the tension, but everyone can see the tension. And frankly, from a privacy consumer protection standpoint, our focus is more on design issues than it is content issues. It gets so politicized, and that's one of the things within, if you try to maintain a multi-state bipartisan effort, one of the things that you probably need to stay away from is things such as political speech. I'll tell you a quick story. Antitrust really picked up momentum between the state and the Department of Justice when Bill Barr became Attorney General. We had already started having discussions or looking at the antitrust issues and with big tech, and there was just a few of us, and we went to set up a meeting with the Department of Justice just to see where their interest level was. It wasn't clear to us whether it was DOJ or FTC with some of these different companies. And what happened was Attorney General Sessions was speaking. We'd set this meeting up. Attorney General Sessions is speaking, and at that time he's kind of under some pressure from the Trump administration. And he's asked a question in a Senate hearing. He goes, yes, I'm going to be meeting with some attorney generals at the end of the month. Well, that's kind of like in junior high when you said you were going to have a sleepover, but you didn't invite some people. The ones who didn't get invited get pretty upset. And so all of a sudden the phones were ringing about, what's this meeting among attorney generals? So we had to work hard to get it set up, have bipartisan representation. I think there are 10 to 12 AGs there. And I think it was Carl Racine and I who were trying to clearly establish the ground rules. Don't go to Section 230. Don't talk about political speech. And I thought it made it completely clear to General Sessions, no political speech. We're talking about antitrust enforcement. And General Sessions sits down, the first thing he looks at us around the table and goes, so what do you think about this political speech? And I look over to his assistant and I go, because it's just something that has the ability to pull us apart. Phil and I both have within our respective parties those who are going to be much more partisan, and that's why it's always been focus on the main harm and stay away from that. So frankly, I haven't had to deal with a lot of Section 230 stuff for the last couple of years.
Let me add one point, because it's a topic that the courts are looking at and has great public policy significance. Whether or not the use of algorithms to channel content in ways that could be harmful is protected by 230. I believe that position is problematic, because it would immunize conduct that looks a lot like an editorial function, not like what you might call a more common carrier-like function. And when 230 was adopted, the theory is these interactive platforms are not playing favorites. They're just letting speech blossom. But when you have algorithms that actually affirmatively channel content to people in ways that people may not realize is happening, and Doug mentioned earlier, young people who say, how do I lose weight, and start getting content that's encouraging bulimia or self-harm, that I don't believe should be protected by 230.
We have a couple questions on this Slido about state laws to prohibit certain types of content moderation. I wonder if you guys see that as a way that states might be moving forward in the ways that they have moved forward with privacy laws.
You know, in the limited amount of policy debate in Nebraska, I think it's more privacy concerns and not so much content concerns that is driving the conversation. I see someone had a question here about several red states enacting laws to prohibit content moderation. I do think from a conservative standpoint, there's certainly a theme that they want thoughts to be freely expressed and not censored. But I would say that even that's a little bit what I was talking about earlier. Once you start going into political speech or restriction of speech, that gets so much more difficult to address, both technically, I think, but also from a policy standpoint. Whereas if you talk about, hey, you're taking my data and you're manipulating algorithms to increase engagement time among teens, those are a little bit cleaner policy issues. So that's where I would think the most potential success is. But frankly, I see that question, and I'm not that familiar with red states who are enacting laws to prohibit content.
Where I see a interesting conversation happening is questions around transparency. What is your content moderation policy, to the extent that can be articulated? And I mentioned algorithms before. Would there be any forms of auditing or oversight of algorithms to make sure that the playing field is fair? This is really, really hard because of the First Amendment issues that Doug mentioned, and its political speech. The challenge we have as a society right now is this rising distrust of all institutions. And if you're a major player and you're serving up content, people are like, what are you serving it based on? That's going to continue to be a question people are going to ask. And a challenge is, how do you address those concerns? What form of transparency can you offer? What form of assurance about your algorithms can you offer? I, like Doug, don't have the answers to that, but I understand why that conversation is happening and is going to continue.
There's one more. Did you have?
Oh, I was just going to say a quick example. If this type of content censorship increases, I think it's to the industry's harm if they continue to do that. The state auditor in Nebraska is a former Navy SEAL and graduated from the Naval Academy. And he had one of his employees, based upon his encouragement, go and apply to the academy and was graduating. So he went to the graduation ceremony. It meant a lot to him. And President Trump spoke at the event. And so he put up on his social media account, I think it was his Instagram, might have been Facebook, but he put on and he said, "Wonderful day." Had a picture of President Trump on the stage. "Wonderful day, very special moment for me to be with my fellow employee as he graduated from the U.S. Naval Academy." And it was taken down. And and he was upset, and he kind of made an issue of it. I don't think it was ever put back up. But if you start taking things down of special moments like that for people, you're going to cause more and more of an uproar. And so I think the industry needs to understand that eventually the populace will have enough of that type of censorship.
Yeah, let me double down on this point. If you are a major platform, Twitter, for example, you have this challenge. Why would you take something down? What's your justification? What's the review process for that? And why won't you take something down? What's your justification of that? What's the review process? Because you can imagine something very harmful, doxing a public employee who's in elections, or you could imagine something innocuous like being a graduation. And that's where, again, transparency. Here's our policy. Here's how we follow it. We've worked that through, for example, the Digital Millennium Copyright Act, to create some framework under some public oversight about how we manage what content stays up, what content stays down. But in this other context, it's still very much in play.
There was one more question on the slide I was going to ask before we open it up more broadly. But Josh Hawley and some others made a name for himself by politicizing investigations as AG to get elected to higher office. As the AGs get more and more involved in all of these digital issues, do you worry at all about more politicized or grandstanding?
I kind of chuckle because I remember when we first started the investigation, and one of my AG friends was in political from a southern state, and he went on to CNBC and he said, "We're going to break up Google, and we're in an investigation state." And felt like he'd kind of gotten out over the skis, and I called him up. And I said, "Hey, you got to pull it back here." He goes, "Doug, I'm in my season." And I go, "Yeah, but I think for the most part we've been able to. I haven't seen anyone run out there and grandstand on any of the issues, frankly, and that's not just Google. That's the Facebook case. So I know what you're talking about with Josh Hawley. I would not, fortunately, I think Phil and I can say this confidently, that we look at the leadership team of AGs involved in this. Some of them easily could, and they don't. And that's why I think we've been able to run. Frankly, it's best for us to pretty much, stay under the radar as we do our work. And I'm glad the character of the AGs we have been very consistent with that. And maybe I shouldn't, well, I won't. I was going to tell a follow-up to the Jeff Sessions story, but what I would say is with that, coming out of that meeting, there were some new Democrat AGs who came from large states who had reputations of being grandstanders. And when we came out of that meeting, all of them, we basically had a script of the purpose of our meeting, and all of them stuck to that. And as newbies, it gave a lot of credibility. To me, it gave a lot of credibility that they weren't there to grandstand. They were there to stay focused on mission. And so that's been the case ever since.
So Doug has done an extraordinary job as a lawyer's lawyer, helping elected state AGs operate with norms that are the highest standards for public law enforcement. I came into this 4 years ago at Doug's recruitment and came into it looking at this work from the standard of how the Department of Justice would have done it during the administrations that I served, where it was very clear you don't politicize law enforcement. And that has been my true north in all the work I've done in Colorado on all issues. And Doug's ability to help that norm be the standard that all of our fellow AGs have been following in this work is an extraordinary accomplishment. We will only have credibility as state AGs when we're seen as serious, doing substantive work on the merits. And if you read the complaints that we've worked on, if you've seen the results that we've worked on, I believe it speaks for itself. I do want to underscore, because the question is here, I can't resist addressing it. Is my current job more political than my prior job where I was a law school dean? This is a much less political job. Henry Kissinger's quote, "The politics in academia are so vicious because the stakes are so small." But Alfred Kahn had an even better one, which is a dean to a faculty is like a hydrant to a dog. Doug is a master diplomat, so the work of coordinating state AGs, herding cats, you know, I don't know how Doug got so well trained to do that, but for me, I'm like, I'll take this over dean of a faculty any day, so.
We have a couple minutes left, so I wanted to throw it open to questions from the audience. We have somebody over here. 1 second, they're getting you a mic.
Thank you. That was a great presentation. Ms. Nyla mentioned as one of the sticking points to the federal legislation, the no-brainer privacy legislation, is preemption. The other major sticking point is the private right of action. And Attorney General Weiser mentioned that you're okay with preemption as long as or I don't want to put words in your mouth, but as long as the state attorneys general have enforcement authority. What about the private right of action? What do you think about the need for that in federalization, or even the propriety of it? None of the Colorado state law doesn't have a private right of action. None of the 5 states do, other than California to a very limited extent. Do you think that that if there were enforcement of federal legislation, privacy legislation by state attorneys generals, that would be sufficient? And do you believe that state attorneys general are better positioned to exercise prosecutorial discretion so that meritorious enforcement actions under the federal privacy law would be brought, but not those, as Attorney General Weiser said, where there's a foot fault by companies that are basically trying to do the right thing?
I would think, well, it's my understanding in California that that was a deal breaker, that if a private action were allowed, that they couldn't get enough support. And I think the happy medium of that is giving the attorneys general under our consumer protection laws the ability to try to protect. And I think it's probably a rational compensation. But I would say if there were private actions granted, it's interesting, having come from the private bar myself, I didn't realize what bad people we were. But I do see some of the harms. You see it in the opioid case. Frankly, this private bar coming in and representing cities and counties and things of that nature is we're on the record, right? Has been a hindrance to moving as quickly as we can to getting money into treatment programs. I don't think there's any question about that. And so, having seen that model as a conservative, I'd rather trust the AGs to be making the calls.
So my view is, as long as the federal law is as good as the Colorado law and I can enforce it, I am no worse off with a federal law. Colorado does not have a private right of action, so I would not hold out for a federal law with one either. If there were any private right of action, I would call attention to the Colorado False Claims Act. We just passed it to address rising fraud concerns out of a lot of the public spending, where the government has this ability to take over a case, to have to green light a case, or to red light a case. So that provides an answer to your concern. And Alan's concern is important here. I am not going to go after foot faults. A world where private actors have the incentive and ability to go after foot faults is a problematic concern that warrants some serious answering. I've heard another answer that some said, which is, how about private action goes into effect years in the future, so we work out foot faults? I don't know if that addresses it or not, but Alan says, no, it doesn't address it. But I recognize the concern Alan says, and it's one I take seriously.
Well, we are at time, so thank you to both Doug and Phil so much for spending a couple minutes with us today.
Thank you.
Yeah.
Glad Paul, Phil, I'm glad you grabbed that question.